So thank you so much for joining us for today's webinar, which is looking at the Queensland Ombudsman, an introduction to their services and investigations. My name's Carly Hanson and I'm one of the Sector Sustainability Coordinators at Community Legal Centres Queensland. Firstly, I'd like to acknowledge the traditional owners of the land on which we're holding today's webinar. In Meanjin, Brisbane, they are the Turrbal and the Yagara people. I wish to pay my respect to their elders, past, present and emerging, and acknowledge that we are on stolen lands and that sovereignty was never ceded. As today's webinar is being viewed by people across Queensland and Australia, I'd also like to pay my deep respects to the traditional owners throughout the country and extend a very warm welcome to any First Nations people who are listening in today. So I'm really pleased to welcome our presenters from the Ombudsman's Office, Anthony Riley, who is the Ombudsman, as well as Principal Investigators Annette Knights and Rhiannon Hunter. I'll hand over to them in just a moment to talk about the Ombudsman. So today's session will cover some case studies from the Ombudsman's investigations and provide you with an understanding of what your clients can expect if they make a complaint to the Ombudsman, who provides free, timely, effective and independent ways to have administrative actions of state government departments and agencies investigated. So firstly, though, I'll do a quick bit of housekeeping. So today's webinar is being recorded and I'll have that recording available for you to download later this afternoon, hopefully. The PowerPoints have been emailed out to everyone who registered as of about 10 a.m. this morning, and they're also available to download from our website and also from the handout section of the GoToWebinar control panel. We certainly encourage you to ask questions, so you can type your question into the question box on the GoToWebinar control panel, and I'll come to those questions at the end of the presentation, but feel free to type them in as you think of them. So I might now hand over to Anthony to kick us off. Thanks so much, Anthony.
Thanks, Carly. And thank you everyone for attending the webinar today. We really appreciate the important role that community legal centres and other community organisations play in assisting people in the community who are dealing with problems with government decisions and helping those people to contact us. So we thought our hope for today's webinar is that it will assist you to understand what we do and how to help your clients. I hope the webinar today sheds some light on the sorts of complaints we can investigate and how we do so. I'm going to provide a short general introduction, and then I'll hand over to Annette and Rhiannon, who'll take you through some really interesting detail about some case studies about how our investigations work, which I hope you enjoy and learn a lot from. Okay, here we go. Okay, so first of all, what does the Ombudsman do? The Ombudsman's Office gives people a timely, effective and independent way to investigate the administrative actions of government agencies. So not private corporations, just Queensland government agencies. Our complaints investigation service is free and confidential. And complaints can be made to us by telephone, email, in writing, or our preference, using the form that's on our website. And using that form is very helpful to us because it gives us all the information we need in a nice structured way. So in terms of the agencies that whose decisions we can look at, they include state government departments, and other state government agencies, like the agency where I used to work, Legal Aid Queensland. We can also look at decisions of local councils and public universities. So we do get lots of inquiries from students. After we've investigated a complaint, we can recommend to the agency ways to fix unfair decisions, actions and services. And while unlike a court or tribunal, our recommendations aren't binding. However, 99 to 100% of our recommendations are accepted by agencies and are implemented, and we monitor their implementation. So it shows that we can be a very effective way of helping people to get the change they need. This slide, I hope, is useful for showing some of the sorts of complaints that we get. As you can see, there's a very wide variety of matters that we cover, from prisons through child safety and housing to local government issues about planning and local laws onto university matters. What you'll notice is not there is the Queensland Police Service. So complaints about the Queensland Police Service are managed by the Crime and Corruption Commission. And also, we also don't consider complaints about Queensland courts and tribunals. All right, so if you help a complaint to make a complaint to us, the first thing we do is to assess the complaint to see if it can be investigated by us, because we can't investigate all the complaints we get, either because it's beyond our jurisdiction, or there might be another better place that can look into the complaint for you. So when we get the complaint, we'll have a look at it, and what we might do is, rather than investigate it ourselves, we might assist you to make the complaint directly to the agency involved. That is, we'll ask you to assist the complainant to go back to their decision-making agency and use their complaints management system to see if they can fix it, because it's important that we give the agency a chance to solve the problem first. Another thing we might do is we might assist you or your client to make a complaint to another review body, that, for example, like the Energy and Water Ombudsman, that is specially set up to deal with certain types of complaints. And then, of course, the other thing we can do is to accept the complaint for investigation. And we accept over 1,000 matters each year that we fully investigate. Okay, so I just want to talk quickly about the importance of contacting the agency first before you contact us. All Queensland state and local government agencies are required by law to have a complaints management system, which we refer to as a CMS. Now, the CMS should be visible on the agency's public website, and there should also be information available about the complaints management system in their offices. And usually, when a government agency makes a decision, they'll have some information about how the person can make a complaint or seek review of the decision in the letter advising of the decision. That's pretty common now and should happen in most cases. The other thing that you might want to, that we would greatly appreciate you do before you contact us, and this will also help your clients because it will help them to avoid going to being moved around between organisations, if you like, is to try and find the correct external complaints body to contact. And it's not easy, and because there are a lot of external complaints bodies, some are private, some are Commonwealth, some are state, and it can be really confusing. So if you want to find a really good list, I would encourage you to look at our website, and we'll have the address of our website at the end of the slides as well. But there's a section there called Other Complaint Handling Organisations, and there's an excellent list of complaints handling organisations that you can rely on to find the right place to go to. And these are some examples of the many other complaints bodies that are out there. So the Crime and Corruption Commission looks into matters relating to corruption rather than us. The Office of the Health Ombudsman is established by the Queensland Government to look at complaints about health services, so we'll ask people to go there for health complaints. Similarly, complaints about Centrelink or the National Disability Insurance Agency, because they're both Australian government agencies, the Commonwealth Ombudsman is a better place to go to for complaints about them. So there's just some examples there of other complaints bodies. So I really encourage you to look at our website to try and find the right complaints body. Of course, if you or your client don't feel unable to use the website or aren't finding what you need there, you're very welcome to contact us. We have a small call centre of great people who will help you to talk through your problem and get you to the right place, including us, if we are the right place. So you can contact us if you are unsure who to complain to. You've used the agency's complaint management system, but the complaint hasn't been resolved satisfactorily, so you feel it does need further review by us. If you're interested in making a public interest disclosure, that is, if your client might be a whistleblower, And also, importantly, if you're in a community group and you're seeing a pattern of significant problems for your clients, feel free to contact us and let us know, because it might be something that we're able to look into. Okay, that's it for me. I'm going to hand over to the what I think is the much more interesting part of the presentation. So over to Annette and Rhiannon. Annette first.
Good afternoon, everyone. My name's Annette Knights, and I'm a Principal Investigator in the Investigation and Resolutions Unit within the Office of the Queensland Ombudsman. Now, one of the agencies that we deal with is the Department of Communities, Housing and Digital Economy, which I'll refer to as the department in this presentation. We get a variety of complaints regarding that agency, but mostly they relate to social housing. Now, today, we really wanted to give you an idea of the type of things that our office is able to assist with and go through a couple of case studies. And we thought it might be of benefit to choose a topic that you may come across in your day-to-day work. So, okay, with the Department of Housing type of complaints, in the housing area, the legislation is at quite a high level, which means it doesn't contain a lot of detail. So all of the detail in relation to how these things are administered are contained in the department's policies. So they have a real extensive array of policies that go into hundreds of pages. If your client gets a decision letter from the department, usually that decision letter would say what legislation and policy is being applied. And there may be situations where you look at it and you think that perhaps the policy or legislation hasn't been applied correctly or fairly. So if it fits into that sort of category, then it's something that we may be able to have a look at. So examples of the type of issues that we can deal with in this area is eligibility for social housing, treatment in relation to the waiting list, transfers and maintenance issues. That's just to name a few. You know, there's a very wide variety of issues that sort of come across our desk. In relation to policy matters, there's a bit of nuance in this, in that there's some things that we can look at and some things that we can't. So if you're concerned about the fairness of the policy itself, that's as opposed to how it's been applied. And you look at the policy and you just think that's just a really unfair policy. We may be able to assist if it's in relation to a lower level kind of policy issue. But if it's a high level policy issue, for example, the way that the government has set its priorities, for example, in relation to how groups of applicants are given priority for social housing, something like that is really it's not our role to intervene in that and would be considered to be out of jurisdiction for us. However, the lower level kind of policies that are more specific and really get down to the nitty-gritty of how a wider policy objective is met, there can sometimes be matters in that we can have a look at. For example, you know, if there was a policy around how income is calculated for the means test, and you know, if it could possibly have an unfair or unintended outcome with the policy drafted the way it is, that's perhaps something that we could look at. So in that sort of case, you know, if we found that it did have that unintended result, then we could recommend to the department that it review its policy. So we wouldn't tell the department what its policy should be. We would just, you know, point out that perhaps it's not operating in the way it was intended, and then they would do that work in reviewing it. Because it is a bit of a nuanced area, you know, if you're unsure at all about whether it is something we can look at or not, by all means give us a call and we can provide some advice to you. There is an area that we're very unlikely to be able to assist your clients with, and that is where something critical has happened or is about to happen. Like, for example, they've received a notice to leave, or a termination order has been sought to have them removed from a property. Once it reaches that point, it really is in the legal sphere. and they need to explore their legal options, which of course in that context would be set out in the Residential Tenancies and Rooming Accommodation Act. Now I'll just go through, I've got the first case study here, where a gentleman came to us. He was a tenant in a Department of Housing block of units, and he'd been having some difficulties with his neighbour in that they didn't get on, and they were both making complaints to the department about the other. And in this case, he came to us and he said that he'd received a verbal warning about intimidation and stalking behaviours. His complaint to us was that he had been falsely accused. He hadn't been given the opportunity to tell his side or defend himself. He said to us, when I asked for evidence like date, time, scenario of what I was meant to have done, they refused to comment. What he wanted was the evidence of the accusations, or for them to take the warning back. So even though it was only a verbal warning, he was concerned about it being on his record, because it can be considered in future matters should other issues arise in relation to his tenancy. The issue that we chose for investigation was whether the complainant was afforded procedural fairness in relation to the department's decision to substantiate the complaints against him for intimidation and stalking behaviours and/or threatening, which formed part of the department's decision to issue a verbal warning. So the first step in our investigation was to seek information from the department. So we wrote to them and we asked for a range of things, including copies of correspondence between the department and the complainant about his complaint, the evidence that the department relied on in substantiating the complaint, advice about how it concluded his behaviour was intimidating or threatening, and relevant department notes. When we received the information, we went through it all carefully, and that information showed that the department was relying on video evidence that had been taken on the neighbour's phone. Now that evidence, so we got a copy of the videos and we watched the video footage, and there were three main videos. One was quite unclear and showed someone filming as they were walking along, and you could just see the bottom of someone else's legs, presumably meant to be the complainant in this case. Another one was video footage of the neighbour. He was pulling out of the driveway and he was filming back up the driveway, and you could just see our complainant walking down the driveway with his keys. And the third video, the neighbour was sitting in his car in the garage area, and there was an open staircase, and they were filming up the stairs, waiting for our complainant to come. And when our complainant came and saw that they were there, he had car keys in his hand. He stood there and waited and watched them until they left. So that was the footage, and the department's notes in relation to the video said could be perceived as intimidating behaviours and loitering in common areas. In the information that was provided to us, there was also a file note of the discussion between the housing officer and our complainant when he was given the verbal warning. And it said that the tenant asked for specific details of allegations, but was advised that we could not offer specifics. The next step in our investigation after we considered that material was that we wrote to the department and we expressed concern that it may not have complied with its procedures, requiring the tenant to be given an opportunity to verbally provide their side of the story, and that it relied on information which was not probative evidence of the conduct. So the video footage, from the way that we saw it, was not particularly compelling, in that if he had been asked for an explanation, if he'd been provided the details of what the allegation was and been asked for an explanation, a possible explanation would have been that he was just walking along doing his normal tasks and encountered this. The one where he walked along and saw them in the garage, he might have said, I saw them there and I didn't want to interact with them, so I just stood and waited till they left before I went down because I was leaving. So he didn't get that opportunity. So the department did not initially agree with us that there was cause for concern, and there was further correspondence between our office and the department around what is actually required for procedural fairness and how this interacts with privacy considerations. And we also had a meeting with the department to discuss these issues. The outcome of this case was that following those discussions with our office, the department decided that while the officers were attempting to provide a fair hearing, the record keeping was inadequate and it was not clear the complainant was afforded natural justice. It decided it would write to the complainant and withdraw the verbal warning. And it also decided to make administrative improvements by reminding officers of the importance of natural justice and keeping accurate and complete file notes. So our investigation was then discontinued on this basis. So often it's not necessary for us to complete an investigation and make formal findings and recommendations to an agency. We find that taking an informal approach and a practical approach can achieve the same results in a shorter period of time, which is obviously very good for both our complainants and for the agencies. So the second case study that I want to go through today is just a short one. This is an example of one where we dealt with we dealt with a complaint on assessment rather than conducting an investigation. So in this particular case, the complainant, her parents were tenants in a department property. The property was a block of units and it was designed specifically for people with disabilities. And her parents were both elderly and they had disability and mobility issues, and they required support workers and mobility aids, and they were at a high risk of falls. There was a loading zone at the front of the unit block, and it was a nice big flat area, and it was used for all of the residents to be able to access cars easily. So if their support workers came over or family members, they could easily go out and get into the car. Now, the department was carrying out some maintenance on the property, and it was quite extensive. It was expected to take several months, and the contractors who were working on it actually barricaded the driveway and the car park, making it inaccessible. And they didn't point out any other easy way for people to access their cars, so that all the residents then had to take an alternate way to get to the cars and walk down a pathway which was about 30 metres long, and it wasn't flat or smooth, so it posed a trip and fall hazard. And our complainant raised the issue with the department over a number of weeks, and she was told that a safe loading zone would be accommodated, but no action was taken. So she came to our office. In assessing the complaint, we looked at the Public Interest Disclosure Act and assessed the information we had against the criteria in that Act. And we assessed the information as being about a substantial and specific danger to the health or safety of a person with a disability under Section 12(1)A of the Public Interest Disclosure Act. So we essentially assessed it as being what we refer to as a PID. Now, Section 31 of that Act says that a public sector entity which receives a PID against another can refer the disclosure to that entity. So in this case, we'd received a PID about the department. So in this particular case, the Ombudsman decided that the department was best placed to investigate this issue and deal with it, and so referred the disclosure to the department via a letter to the department's Director General. The outcome of that matter was that the complainant advised us that within a few days of the referral, a safe access point was identified and implemented, and further information was provided to the residents about the work that was being done and how long it was likely to take. So this is really an example that we don't always need to do a full investigation. Sometimes our involvement can actually highlight an issue of concern, and this can sometimes affect the priority that's given to it. So that's it for me at the moment. So I will pass over to Rhiannon.
Thanks, Annette, and thanks everyone. My name is Rhiannon Hunter. I'm a principal investigator, also in the investigation and resolution unit within the office. I'm going to talk about child safety complaints. So child safety currently sits within the Department of Child Safety, Youth Justice and Multicultural Affairs. My presentation is going to cover a little bit about the child safety complaints management system, some of the other key players involved in the child protection system, what the Ombudsman can and cannot assist with, and then I'm also going to have a little case study. So just talking about the child safety complaints management system, this office has actually conducted two own initiative investigations, so a more systemic style investigation looking at the how the child safety complaints management system operates on the whole. The first of those investigations, the report was published in July 2016, or tabled in Parliament rather. That was more of a look at, I guess, what the data told us. So it was a little bit more of a superficial look, and recommendations were made about, I guess, the quality and integrity of that data to enable us to have a more in-depth, detailed look down the track. And so that then was the reason we had our second investigation, where the report was tabled in Parliament in March 2020. So that investigation delved a lot deeper into the CMS processes and identified areas for improvement. There were 9 recommendations made in that report, all to, I guess, improve the customer experience when they were engaging with the department's CMS. And so a couple of other agencies that are, I guess, key players in the child protection system. We've got the Office of the Public Guardian. So they've got their community visitors and child advocates. So their community visitors can help a child or young person express their views to a child safety officer. They can help them with issues relating to education, health or counselling. They can help them access support services, make changes to their care arrangements. And then you've got their child advocates that are more around assisting children with advice about legal issues, resolving disputes, making complaints, having their views or wishes expressed in courts or tribunals. And then we've also got the Queensland Foster and Kinship Care Agency, which is about supporting foster and kinship carers, so they can provide advice, support and advocate on behalf of the other of foster and kinship carers. So they're more of a support advocacy type agencies, whereas the Ombudsman plays a much more impartial role when we receive complaints. So just covering off on what we can and cannot assist with. So firstly, what we can't or will not assist with. So we don't have the power to investigate or respond to reports of harm or risk of harm. So these reports of harm or risk or harm should be made to the relevant regional intake service of the department. Anyone can contact the department with concerns about a child who is at risk of harm or who has been harmed. There's 7 regional intake services across the state, and all those contact details can be found on the department's website. The Children's Court, so obviously applications, as you will all well know, applications for child protection orders are made in the Children's Court, and the office doesn't have jurisdiction over the courts or judicial officers. Also QCAT, as Anthony's previously mentioned, we don't have jurisdiction over the tribunals. So obviously there are some decisions made by the department that do have that right of review through QCAT. So decisions like who will care for the child, conditions on contact, and removing a child from a particular carer. I'm just moving along to what we can assist with, or what we may assist with rather. So this is by no means an exhaustive list. So similar to the Department of Housing complaints that Annette spoke about, it can get a little nuanced about what we can assist with, but some examples include the department's response in relation to reports of harm. So if someone doesn't feel as if their report of harm has been dealt with appropriately, they can certainly come to us and make a complaint about that. Some aspects of the investigation and assessment process. So where an investigation and assessment has determined that a child is not in need of protection, but they may have substantiated harm. We have received complaints from individuals who they are the, I guess, perpetrator or alleged perpetrator of the harm, but they have no avenue of review because the outcome of the INA has been that the child is not in need of protection. So they've come to this office to make a complaint about that. Various aspects of kinship and foster care. So for example, standards of care reviews, where the department hasn't provided sufficient support to the child, kinship carer or foster carer. For example, providing financial or medical support. While the office can't investigate matters in relation to the child protection orders themselves, there's sometimes some peripheral matters that we see that we may be able to assist with. So, for example, a parent who might be going through that process with the department is having some service delivery type issues. They're not getting the communication that they expected, they're not getting callbacks, things like that. We may be able to assist with those types of service delivery complaints. And also complaints about the department's complaints management system itself, so how that's operated and people still being dissatisfied at the end of that. So how they've handled the complaint through the CMS itself. So those are just some examples. It can get a little nuanced, as Annette and Anthony have both said. If you are at all unsure about whether it's an issue that we can deal with, certainly contact our intake area and they will be able to provide some advice in that regard. So just moving along to the case study. So this office received a complaint from a foster carer about a change in medication for a long-term foster child in her care. The child had been diagnosed with multiple behavioural and cognitive disabilities, and following the child's escalating violent behaviour, placing the family at risk, the foster carer made an appointment with the child's paediatrician. The paediatrician prescribed a new medication for the child, and so the foster carer sought the department's urgent approval for this change in medication. The foster carer followed up with the department on multiple occasions, but the department didn't approve the medication change until 3 weeks later. The delay in approving the medication meant that the child was forced to withdraw from their current medication without the stabilising effects of the new medication, and this resulted in even more violent behaviour by the child, including an incident where the police and ambulance had to be called. So the foster carer made a complaint through the department's CMS, and after receiving the outcome of the initial complaint, they sought an internal review. They had multiple grounds for seeking an internal review, including that the department didn't address some of the initial complaint issues and failed to consider her feedback. Once they received the outcome to the internal review, the complainant remained dissatisfied and so came to this office. So The issue for investigation was whether the department's response to the foster carer's complaint about delay in approving the medication change was reasonable in the circumstances. The complainant highlighted some particular issues in terms of the department's handling of her complaint, including the reasons for delay in approving the medication change. The department did not view the urgent change in medication as emergency treatment under the Human Rights Act 2019, and therefore may have breached the child's human rights. The department did not provide reasons why the foster carer's feedback did not alter its preliminary views at both the initial and internal review stage. And the department advised the foster carer that changes had been made to the medication approval processes, but did not provide details of the changes. The foster carer actually advised this office that even after the department had advised of changes to the processes, she had experienced further issues with the department about a change in medication to one of her foster children. And so just on the point about the Human Rights Act, it's the relevant section there is section 37, which states, which is about right to health services, and subsection 2 says a person must not be refused emergency medical treatment that is immediately necessary to save a person's life or prevent serious impairment to the person. So that was the relevant provision that the foster carer felt had been breached for her foster child in this case. And so the investigation, at the outset of the investigation, we contacted the complainant, just making sure that we understood all of her issues and concerns, ensuring that she understood, I guess, what this office was going to have a look at. So we were on the same page and we were managing her expectations up front. We also assessed the material that the complainant provided, and this then informed requests to the department for documents and records. So the documents and records we requested were relevant to the action taken by the department to approve the medication change, the department's reasoning for not deeming the medication change emergency treatment in accordance with the Human Rights Act, and the department's management of the foster carer's complaint. So once we received all that information from the department, there was quite a volume of information, trawling through that, there were phone calls between this office and the department to clarify some of the requested information. And then along the way, we were also providing the complainant with regular updates about the progress of the matter, and just continuing to manage her expectations in that regard. And so some of the findings in the investigation were that the department did not make formal findings about the delay in approving the medication change when dealing with the foster carer's complaint. So they actually did accept that it was the primary complaint issue, yet they didn't in fact provide a clear outcome at the conclusion of her complaint through the CMS. The department did provide this office with evidence of having considered the child's human rights and why it did not deem the change to medication as emergency treatment. And this reasoning appeared to be reasonable, but they didn't communicate that or even address it with the complainant. It was sort of silent on that issue. So hence the complainant not understanding why they hadn't turned their mind to that. The department didn't provide adequate reasons as to why the foster carer's feedback to its preliminary reviews did not alter the outcome of the initial complaint and internal review. So the department does, rightly so, provide complainants with an opportunity to give feedback on their preliminary review before they finalise the complaint and internal review processes, but it didn't seem to alter it in any way, and the decisions provided to the complainant didn't demonstrate that they had considered her feedback in any way. The department didn't provide adequate reasons as to why they made a procedural change to medication approvals or the nature of the change. So you can sort of understand why the complainant was a little frustrated in that regard, because she's obviously identified that there was a flaw in the process that she was engaging with, but has no idea of how this was remedied. And just another note, just in relation to the issue of emergency medical treatment, the department did advise this office that in emergency situations, a health practitioner has authority within the Act to administer urgent medication without prior departmental or guardianship approval. So there is that sort of, I guess, safety in those emergency situations, and it wasn't, and they are reliant on the advice of medical practitioners in that regard, and so it wasn't deemed emergency treatment in this case. So the outcome is perhaps not what you'd expected given some of the findings that were made throughout the investigation, but the department came to us during the investigation to advise that it had revised its internal review procedure, which was previously just a process-only review. So they'd simply go through and say, well, did they follow the CMS process as it's set out in the policy and procedure? Yes, they have. There was no merits review of the outcome itself. And that was actually a recommendation that was made by this office in the second CMS report that was tabled in Parliament in March 2020. So they finally implemented that. And because of the conversations that we were having with the department throughout the course of this investigation, they actually identified and agreed that the foster carer would have benefited from a full merits review of her complaint. And so this office also agreed that it was probably, given the department was sort of recognising some of the failures in their processes, and they now had this avenue of a full merits review, that was possibly the most expeditious way for the complainant to have her complaint dealt with. So the investigator from this office spoke with the complainant about a proposal to refer the complaint back to the department, who had agreed to conduct a full merits review. And we explained what the full merits review process would entail, as opposed to what she had previously experienced. And the complainant was actually very pleased with this outcome. So the outcome was confirmed in writing with both the department and the complainant. And then after some time had passed, the complainant had been through this full merits review process, she had actually taken the time to write to this office and provide some very glowing feedback to the investigator. She was really grateful for having felt heard and expressed new hope and felt empowered to pursue new pathways in working with child safety to enhance the well-being of the children in her care. She actually had a number of foster children in her care. So that was really wonderful feedback. We don't often always receive good feedback, but it is lovely when we do. And so some of the, I guess, learnings that we got from this investigation, I guess investigations are rarely linear and need to be quite fluid. So, you know, we were obviously heading down a particular path, we were making some findings, but as Annette pointed out, it's not always that really that formal findings need to be made to get the desired outcome. We can often, you know, a new avenue pops up mid-investigation and we go with it because it looks like the most appropriate avenue to have the complaint dealt with. So in this case, it was the full merits review. And so we sent the complaint back to the department. Another lesson was that complex investigations can have a seemingly simple outcome. So despite the volumes of information that was reviewed in this case, the extensive conversations that was had with both the department and the complainant, it resulted in something that seems relatively simple in, you know, we're sending the complaint back to the department. But it certainly got the complainant the outcome, the most desired outcome. So, and it was the quickest avenue for her to do so. So, and I guess the final learning was that communication is key. So that managing expectations, keeping the complainant up to date throughout the investigation, I think was key in this instance, because you can probably imagine if the first point of contact was us having a conversation about wanting to send her complaint back to the department. She understood, I guess, the level of scrutiny that was given to the information she was providing, the information that we were obtaining from the department. She understood that this was the most appropriate avenue for her complaint to be dealt with, and she was very grateful in the end. So yeah, those were some of the lessons of that complex investigation with a seemingly simple outcome. And so that actually concludes our presentation. Thank you all for your time and listening in to what we do here at the Office of the Queensland Ombudsman. That's our website. It's a really great resource. It has a lot of very useful information. Anthony's pointed to a few places you might like to go that may assist your clients. We've also got all our contact details up on the website, which includes our phone number to the intake service. We've got interpreter services. You can also write in. It's got our email address, or you can also attend in person at level 1853 Albert Street, Brisbane. So thank you very much again. Handing back over to you, Carly. We're happy to field any questions.
Fantastic. Thank you to Anthony, Annette and Rhiannon for sharing some information and some great case studies. There have been quite a few questions that have come through, so we've got about 10 minutes to deal with those. So hopefully we'll be able to get through as many as we can. So firstly, there's a couple of questions around the sort of average time that it takes for an investigation to be concluded. So do you have any guidance on what your current sort of timeframes are at the Ombudsman?
Yeah, when we first receive a complaint, the first thing that we do is to assess it, to see whether it's within our jurisdiction and to see whether it's within time, because we will only deal with complaints that are about matters that are less than 12 months old. And we also look at whether they've been through the complaint process within the agency first. So if all of those criteria are met, then it will be, so that initial assessment is usually done within 30 days. If it then meets all of those criteria and is referred to an investigation team, then we certainly, it's hard to say exactly how long each investigation will take, because they are all very different, and it depends how complex they are. A straightforward investigation we usually try to complete within 3 months, but some more complex investigations can go longer than that. So it's really hard to say, because it really depends on the particular matter. So does that give you an idea?
Yeah, that's great. So a follow-on question from that would be if the complainant had sort of progressed through the internal mechanisms in the department, does the time frame of 12 months begin when the issue first originated, or at the conclusion of the department's internal processes?
Well, generally people are complaining about the response that they get from an agency about their matter of concern. So generally the time will go from when they receive the outcome of their internal review request. So, whenever the department expresses its final view to a complainant, that's usually when the time frame would start.
Mm-hmm. Great, thank you. So the next question, and I also had this one in mind, is how the Ombudsman intersects with the Queensland Human Rights Commission. So what would be the best way to identify whether a complaint to the Ombudsman is best avenue versus a complaint with the QHRC?
Hi Carly, it's Anthony here. I'm coming back to the microphone. That's a really good question. So before, Annette referred to that assessment process when we first get the complaint. One of the things we do when we assess every complaint is to see whether it has a human rights component. If we think that it is actually a matter that might be considered by the Queensland Human Rights, or might be best considered by the Queensland Human Rights Commission, what our intake team will do is provide the complainant with that option. So we'll say to them, this might be best handled by the Queensland Human Rights Commission. Would you prefer to go down that path? and if they do, then we'll assist them to take that path. But if the person wants to stay with us, we will keep it here. So so each matter is assessed for those human rights issues.
Great, and I guess something to consider for your clients when you're speaking to complainants is the time frame. So I think at the moment the Queensland Human Rights Commission has quite a backlog of matters and is looking at around, I think last I heard was around 6 months. So it may be quicker through the Ombudsman potentially at this stage. So another question that's come through is whether the Ombudsman has powers to compel a department to provide information.
Yes, the Ombudsman has very strong powers under the Ombudsman Act. However, the way we do most of our investigations is we don't need to exercise those powers most of the time. Occasionally we do, but most of the time we don't, because agencies support our work and usually assist us. So yeah, we do have the powers as backup if we need it, but very rarely do we need to use them.
Oh, that's great. If the Ombudsman, once it concludes its investigation into the matter, if the complainant is still not satisfied, what's the next step for them? Is there any further review or avenue available to them? They're not happy with the outcome?
Thanks, Carly. We do have an internal review mechanism within this office as well. So if they're dissatisfied with the outcome to their initial complaint with this office, we put information in those outcome letters about our internal review mechanism. They do need to have grounds to engage with that internal review process. So it's not a simple, I'm dissatisfied with the outcome. They need to come with some clear grounds as to why they think the initial decision was flawed in some way, whether we failed to consider a piece of information. But yeah, we have a separate internal review team. Once the internal review decision is made, generally that's the end of the line for most of the complaints dealt with by this office.
Great, hopefully that's answered that question there, thank you. There's another sort of follow-on question from the human rights intersection question. So this one is whether if the complainant has that choice so they come to the Ombudsman, you provide the option of the Queensland Human Rights Commission and the client opts to stay with the Ombudsman. Is there a human rights consideration of the complaint through the Ombudsman or not? And how does that work?
Do you want to
I guess we still are mindful that is an issue within the complaint. We obviously also consider for ourselves whether the decisions that we are making are impeding the human rights. So we have obviously our own internal consideration of the complainant's human rights. Might have to take it on notice just to see how that interface actually works when a complainant actually does pursue a matter through the Human Rights Commission. Certainly, as with the example that I gave, that was a matter that was exclusively dealt with by our office.
Yeah, I think that's a good point, Rhiannon. How about what we could do after this is I could ask our intake team to make a few dot points about how we interact with the Queensland Human Rights Commission and through our assessments and investigations, and we can send those out if that's of assistance.
Yeah, that would be great. Thank you, Anthony. Wonderful. And we can
it's really interesting. There's a lot of the questions, by the way. Great, thanks.
Yeah, thank you. So there have been a couple of questions that have come through, and apologies, I don't think these ones would be able to be answered by the Ombudsman because they're actually in relation to timeframes around resolving complaints with the Health Ombudsman and also an NDIS AAT sort of Commonwealth Ombudsman question. So unfortunately, I don't think I'll be able to, unless the Queensland Ombudsman has some intel, but I don't suspect that they'll be able to answer those kinds of questions. It might be best to those people that have asked those to contact those other ombudsman agencies and ask those questions. So the final one that I might put to you is just around whether the Ombudsman has access to interpreters for complainants who might require interpreting services.
Yes, we do, Carly. So we've got interpreting services. So there's a number 131450. That information will also be on our website. But yes, we are enabled to have interpreters if needed.
Great. All right.
And I'll just throw, our website also has this nice technical feature that you can change the text to the language of your choice, so people can read it in their whichever language is easiest for them to read in if they need to. So hopefully that's of assistance too.
Great. Well, thank you so much. That's all our questions. Oh, actually, as soon as I say that, there's always one more question. So I might just check that one. Okay, so if we were to provide information about recurring problems, what sort of actions does the Ombudsman take? So I guess maybe this is more of a systems issue, perhaps, rather than an individual complainant issue.
Yeah, so Rhiannon referred before to an own initiative investigation. So the Ombudsman, while most of our investigations are in response to complaints that people make formally to us, we also have the ability to investigate matters because we choose to, and they're called own initiative investigations. And our own initiative investigations will usually be based on some problem we're seeing, a recurring problem or an issue we think needs to be looked at in more detail. And so information of the type that you just mentioned from community groups about issues can be very useful to us to understand what's concerning people in the community and whether we ought to have a look at it. So we'll then exercise our, if that information comes through, we'll have a look at it and exercise our discretion as to whether we think it warrants some follow-up. And the follow-up could be in varying forms. But so yeah, we do welcome that and we're interested to receive it. Thank you.
Fantastic. Well, thank you. That does bring us to the end of our questions and to the end of our session today. So on behalf of everyone who's joined us, a big thank you to Anthony, Riley, Annette Knights and Rhiannon Hunter from the Queensland Ombudsman's office. I will also just remind everyone that there is a short survey that will pop up on the screen once the webinar is closed. So that's really helpful to us and our presenters to help improve these webinar sessions for you. If you do have any thoughts or other questions that you might think of, feel free to send those over and we'll make sure to get the recording and that additional information from the Ombudsman out to everyone as soon as possible. So thank you again to our presenters and to everyone for your great questions this afternoon. Hope to see you at our next webinar in a couple of weeks.
Thank you.
Thank you.
Thank you.